give you an overview of the criminal justice system in America. The systems range throughout the country are somewhat different, but they all achieve the same purpose. There are basically four parts of the criminal justice system: the arrest phase, the prosecution phase, the arraignment phase in court, and the correctional aspect. These components all go together to make up the criminal justice system. As I said earlier, they vary depending on the county, state, and also the federal level. As you know, there are various arresting agencies in this country: the FBI, Secret Service, as well as the Metropolitan Police Department. Let's start with phase one. When a person is arrested, there's probable cause to believe that he or she has committed a crime. At that point, the police officer will escort the individual under arrest for processing. There are several things that happen during the processing stage. The person is booked, as they say sometimes. During that process, the police officer will run a criminal record check to see whether the person has any other charges or is wanted by other state or county officials. He or she is also fingerprinted, and that information is sent to the FBI. Subsequently to that, the individual is brought before the court for what is called the initial appearance. At that time, the prosecutor will determine whether or not there is probable cause to believe that this individual has committed an offense. It's over that point that if there's no probable cause to believe, the person can be released, and it's called no paper. The case is then no paper. If the prosecutor feels that the individual has committed offense, he will hold the case for what is called a preliminary hearing. At this point, the defendant appears before the court for what is called again the preliminary hearing. It's at that time the prosecutor will present evidence before the judge as to the defendant's conduct in the community for that particular crime. If the court finds probable cause at that point, the individual will be detained for an arraignment. It is also during that time that the charges can be lessened from, for example, assault to simple assault. And also the defendant may be able to plead guilty to a lesser included offense such as simple assault. If not, the case continues to the arraignment part. The arraignment part will consider the defendant appearing before the court, at which time he or she will plead guilty or not guilty to the formal charges presented by the prosecutor. The formal charges are made up in two forms. One is called an indictment, the other called an information. The information is the formal charges, written charges by the prosecutor. The indictment is handed down from the grand jury. At the time the defendant, if he pleads guilty to the offense, a trial date is set. During the trial, if the defendant is found guilty, he is then sent to the probation office on preparation for a pre-sentence report, and sentencing is set. At that time, the defendant is sentenced, and he's incarcerated at the criminal justice system part. He will remain in custody of the Department of Corrections or whatever correctional facility for the time he is sentenced and released on parole.